Good evening, ladies and gentlemen, and welcome to True Grit Crime. I am your host, Mama Libra Scales. Today, I would like to share with you the tea that went down. So, I was able to go to Mitchell Westerman's hearing today. It was scheduled for 1:30 initially on the docket. It was stated that this hearing was supposed to be a pretrial conference as well as a motion in limine. So, as we all know, court was supposed to start at 1:30 p.m., which it did. Like, the judge is so super great about getting everyone going and starting on time and things of that nature. And so, one thing I have to say um, is that I have never. Hi, Fiend. Welcome. And you are welcome. Like, I don't mind doing this. I don't mind going and making the trip and being able to give everybody the information that they need. Um, it, it, there's so many things that are left unanswered, so many things that we don't know. So, um, I take it as my honor to be able to go and help bring that information and bring the awareness, not just for this case, but for everybody. Um, so anyways, uh, so this courtroom is by far the loudest courtroom I've ever been in my entire life. This courtroom today was filled to the guild. So on each side, there are 5 rows of chairs with, except on the left side, there's 5 rows, but there's 3 chairs at the last row, and the other 4 rows are 5 chairs. So essentially you have like a little less than 50 chairs there. And then you obviously have like the jury gallery is like on this side. Then you have the prosecutor's desk, the defense's desk. Then there's a desk for a probation officer, and then another part for like the little court reporter, and then the judge. Let me tell you guys, this place was hopping. Every single seat in that room was filled. They had people standing. And so they're all talking. It's so loud. And what I'm not used to is usually when proceedings are going and a judge is talking to a defendant and, trying to get all of their plea and all of that stuff like lined out. This was totally not it. These people were like talking really, really loud. It's crazy. So the docket list, Westerman initially was like listed pretty far down on the docket list. And with as many people that were in there today to see the judge, we knew that we were going to be sitting for like a hot minute. So we're sitting there, and about 1:30-ish, 1:36-ish, after his attorney and Westerman, get in there. Westerman's attorney is talking to the prosecution for a few minutes. Next thing you know, he leaves the courtroom. And so it's like, okay, where's he going? A few minutes later, at exactly 1:36 p.m., Westerman tries to dip up out of the courtroom as like unnoticeable as possible, but it was noticeable because that courtroom was so packed and like everybody was sitting there that people, when they wanted to get out of the row, instead of like walking across somebody, they would go up outside of the aisle, and then they would walk on either side behind either the prosecution or the defense's desk to be able to get out of there. So Westerman is trying to make this beeline to get out of the courtroom, and he's like struggling to get behind these like little chairs for a second, and he goes to put his hand on this little wave door, you know and he just kind of looks up for a second, and he just had this look like, I don't know, I would describe it as, I don't know if it was like a nervous look or like what, but he abruptly leaves the courtroom. And so Rescue All Dogs was sitting next to me, and she was like, I'm getting up and I'm going to go see where in the world he went, because it's super like messed up. You know what I mean? Like, and I was like, well, maybe he had to go to the bathroom. So she goes out and she walks around, and she comes back in, and I don't see him. And so she had asked Frank Meister if he would get up and he would go possibly look in the bathroom to see if he saw Westerman, or if he saw Westerman's attorney. So he goes to the bathroom, he comes back, he's like, I don't see them anywhere in the building. So he's like, I wonder, everybody's sitting there wondering what in the world is going on. Like, what? Right? So he gets up, Frank Meister gets up, and he goes over to speak to somebody and asks them, hey, what's going on? Somebody assures him everything's still good. It's still good. Everything's fine. And so he sits back down, and not too long after that, Westerman's attorney comes back into the room, but Westerman does not come back into the room at all. So he's like gone. So we're thinking, because there were some defendants that were because the courtroom was like, so full of people, some of the defendants were going into other places to kind of sit there and wait to go in front of the judge. And so they do have an upstairs atrium, I guess, up there for other courtrooms. And so somebody had said that he had been upstairs. He was upstairs. And so we're sitting there, and this is going by, like, people are going in front of the judge. It's hitting 3:02 p.m. There's still a lot of people. 3:12 p.m. still a lot of people. 3:30 p.m. comes, and we're down to 2 defendants. 2. So the last guy gets up, and he's getting in front of the judge, and we're like, okay, it's got to be coming, right? It's got to be coming. Y'all, it didn't come. It didn't come so much that they did nothing. They're like, Westerman or his attorney did not go in front of the judge, did not say 2 words to the judge about anything. And it gets down to the last defendant. The judge is like, okay, I'd like to get this finished before I go home for the day. I'm like, wait a minute, go home for the day? What do you mean? Like, Westerman ain't even got up there. What's going on? So, of course, he gets through the last defendant, and they turn the time clock off. And Frank Meister walks over to the prosecutor, and he's like, hey, man, what is going on? He was like, Westerman was supposed to be, going through this thing. He's like, this was scheduled for 1:30. He's like, what's happening? And the prosecution kind of like gave this dirty look to him. And before she answered, and she said, I can't tell you what's going on. You're going to have to go to the clerk. Okay. So Frank Meister goes to the clerk's office, and the clerk's office notifies Frank that there has been a pretrial diversion agreement reached between Westerman and the prosecutors. So that is insane. And if you're asking yourself, what in the world is a pretrial diversion? Well, we're going to go ahead and we're going to talk about what the pretrial diversion is. So I'm going to go ahead and I'm going to share my screen for those who may not know what it is, understand, or whatever, so that we're all on the same speed together. So a pretrial diversion in Indiana is a program that allows certain criminal defendants to avoid conviction by completing a set of conditions prescribed by the prosecutor's office. The availability of pretrial diversion programs varies by counties in Indiana, and generally, the program is only available to first time offenders or individuals who have committed nonviolent crimes. However, even if a defendant is eligible, the opportunity to participate in a diversion program is completely at the prosecutor's discretion. Defendants who take part in pretrial diversion program are typically required to complete certain conditions, such as community service, drug testing, counseling, or other rehabilitation programs. If a defendant successfully completes the program, the charges against them are typically dismissed and they avoid a conviction. Aurora and Bernard, you guys need to calm down. Thank you. So they may avoid a conviction. In contrast, if the defendant fails to complete the program, they may be prosecuted for the original charges placed upon them. Laws on pretrial diversion in Indiana. The laws regarding pretrial diversion in Indiana are located in Indiana Code 33-39-1-8, which clearly states that a prosecuting attorney has the ability to withhold prosecution against an accused person if the person is charged with a misdemeanor or a level 5 or 6 felonies, and they agree to the conditions of the pretrial diversion program offered by the prosecutor. If the person agrees to the conditions, the terms of the agreement shall then be recorded and signed by both person and the prosecuting attorney, and then filed in court where the charges are pending. Any agreements made under this subsection of Indiana law can place a variety of conditions upon the person entering the pretrial diversion program. Some examples of these conditions include requirements like work faithfully at a suitable employment or faithfully pursue a course of study or career and technical education that will equip the person for suitable employment, undergoing available medical treatment or mental health counseling, and remain in a specified facility required for that purpose, including addiction counseling, inpatient detoxification, and or medicated assisted treatment, including a federal Food and Drug Administration approved long-acting non-addictive medication for treatment of opioid or alcohol dependency. Refrain from harassing, intimidating, threatening, or having any direct or indirect contact with the victim or a witness. Receive evidence-based mental health and addiction, intellectual disability, developmental disability, autism, and co-occurring autism and mental illness forensic treatment services to reduce the risk of recidivism. Support the person's dependents and meet other family responsibilities, makes restitution or reparation to the victim of the crime for the damage or injury that was sustained, report to the prosecuting attorney at reasonable times, answer all reasonable inquiries by the prosecuting attorney, and promptly notify the prosecuting attorney of any changes in your address or employment. Participate in a dispute resolution, either under Indiana Code 34-57-3 or a program established by the prosecuting attorney. Pretrial diversion eligibility. Per Indiana Code 3339-1-8, pretrial diversion is not available to several types of offenders. First and foremost, anyone charged with murder or a level 1, 2, 3, or 4 felony is not eligible for pretrial diversion in Indiana. In addition, a person charged or arrested for operating a motor vehicle as described in Indiana Code 930-5-1 through Indiana Code 9-30-5-5, illegal possession of alcohol by a minor if the offense occurred with the offender while the offender was operating a vehicle, driving with a suspended driver's license, or in violation of restricted driving privileges, obstruction of traffic by use of motor vehicle, or criminal mischief as a Class B misdemeanor. If the alleged offense occurred while the person was operating a motor vehicle and this person was less than 18 years old at the time of the offense. Furthermore, a person who holds a commercial driver's license and has been charged with an offense involving an operation of a motor vehicle in accordance with the Federal Motor Carrier Safety Improvement Act of 1999, also regarded as the FMCSIA, is not eligible for pretrial diversion. This law, which was created by Congress to improve the safety and operation of commercial vehicles and their operators, established a variety of regulations that drivers with a CDL must follow or risk incurring a penalty. Some examples of violations under FMCSIA include operating a commercial motor vehicle without the required license or with the suspended or revoked commercial driver's license, operating a commercial vehicle under the influence of drugs or alcohol, falsifying reports or documents related to hours of service compliance like logbooks or electronic logging devices. If the offender has not been arrested or charged with any of the criminal offenses listed above, then it will be up to the prosecutor to decide whether it's appropriate to offer the chance at participating in a pretrial diversion program. When making this determination, a prosecutor will often consider several factors, including but not limited to the nature of the crime, the defendant's criminal history, and the prosecutor's policies in the county where the case is being heard. Given this, certain type of offenders are generally more likely to be considered for pretrial diversion in Indiana than others. Offenders that are more often given pretrial diversion in Indiana. First-time offenders. Pretrial diversion is typically reserved for first-time offenders who have no prior criminal record. Defendants who have a history of criminal conviction or are currently on probation or parole are less likely to be granted pretrial diversion. Nonviolent offenders. Pretrial diversion is more commonly available for nonviolent offenses such as drug possession, property crime, and other non-violent misdemeanors. Low-level offenders. Pretrial diversion is generally reserved for lower-level offenses such as misdemeanors rather than felony charges. Defendants with strong ties to the community. Prosecutors may be more likely to offer pretrial diversion to defendants who have strong ties to the community, such as stable employment, family support, and a history of community involvement. Defendants showing remorse. Defendants who show genuine remorse for their actions and take responsibility for their behavior may be more likely to be considered for pretrial diversion. It's important to note, however, that each case is unique. Therefore, the eligibility criteria for pretrial diversion can vary depending upon the facts of the case, the county in which the person has been charged, and the policies of the prosecutor's office. Now, the benefits of participating in a diversion program. Pretrial diversion in Indiana offers a variety of potential benefits for eligible defendants. While the biggest benefit of participating in a diversion program is certainly the ability to avoid traditional criminal penalties like incarceration, it's also a great way to promote speedy resolutions to criminal cases. This means defendants can address their charges in a timely and cost-effective manner, especially when compared to a lengthy criminal trial. For many offenders, pretrial diversion programs also offer the chance to address and rehabilitate some of the underlying issues that may have led them to commit a criminal offense. This is often seen through mandatory participation in counseling, drug or alcohol treatment, or educational conditions that are aimed at providing the offender with support and resources required to make a positive change in their life. More importantly, pretrial diversion in Indiana provides offenders with a second chance. Under most circumstances, the successful completion of an Indiana diversion program allows individuals who have been arrested or charged with a crime to avoid having a conviction on their criminal record. The reason this is so important is that the sheer existence of a conviction on your criminal record can have significant long-term implications. Given this, pretrial diversion programs are a great way for offenders to protect future employment prospects, housing opportunities, and other aspects of their personal and professional life without having to pursue an Indiana expungement in the future. Want to explore a pretrial diversion program? If you're facing criminal charges and are interested in exploring your options for pretrial diversion in Indiana, it's important to consult with an experienced criminal defense attorney first. They can advise you on your legal options given the jurisdiction and circumstances of your case. If you need help determining your eligibility for pretrial diversion, uh, Keffer Hashar LLP has a team of Indianapolis criminal defense attorneys that are available to assist you. Our attorneys will work all throughout the state of Indiana and have a solid grasp on how diversion programs differ county by county. To speak with an attorney, call that number. So, yeah, that kind of gives you an idea. Hey, stop it, you two. That kind of gives you an idea. Hi, all eyes on Delphi. Welcome in. Hi, Old Mort, Big Fish, Small Pond, Luis, Andre, Aaron, Town. Something to say. Thank you guys so much for coming and listening and showing your support. So today was like a lot because I really thought that um, even filing for the pretrial diversion, I felt like maybe um, something should have been like put on record in the court. But the clerk's office said that the documents had been filed. However, they had not been posted to the docket as of yet. So anyone who was there at that given time at that moment was not privy to those particular documents at this time. I guess after they're posted, then yes, you're privy to it. I just really feel like this is just mind blowing. Because I feel like what was the point in giving somebody who would take things that don't belong to them a slap on the wrist? I don't understand that. And I don't agree with that at all. It just, it's not right. It's really not right. Also, today I learned some interesting things from Rescue All Dogs, who was available to go to the last hearing that Mr. Westerman had. I was unable to attend the last hearing. And she told me that not only did the judge want to hold off and see like what was happening with the trial in Delphi before they pursued it, and they started doing stuff to deal with Westerman. I was unaware that apparently there was a conversation of yet again missing discovery items. So that I found to be like a really interesting tidbit of information. And I thought, wow, what are the odds? Right? It's just it's so much. But I'm not surprised by it at all, I guess. There was absolutely no formal media at this hearing at all whatsoever. No cameras. Which is an extremely vast difference from when this case first started. So when this case first started, the first time that I went, which was his initial hearing, there was a camera that was posted outside of the courtroom, and there were at least two individuals from two separate media entities that were there. Nobody was there with a press pass except for me today. So I found that to be pretty interesting. I'm wondering why wasn't somebody sent out to kind of like cover this and talk about it? But who knows? And let's see. I think that's really like all that kind of like went down today as far as all that goes. I sat through a whole lot um, of people being sentenced today. One of the craziest things that I did see today is there was this guy who was being prosecuted. Like, he was an 18-year-old kid and he was driving in his car apparently on the interstate, and he got some form of road rage and he pulled his um pistol out and he shot at a vehicle with 4 people inside of it, and obviously like criminal recklessness. uh that he was charged with a felony and it was dropped to a misdemeanor today, and then he was offered like a pretrial diversion program. So it was really like, I'm shaking my head and I'm wondering, like, you fired bullets at somebody's car driving down the interstate. I don't understand that, but I don't know. I don't know if it was pretrial diversion. He was offered something else, like oh, that's what it was. It drops to a misdemeanor at the end of his probation. That's it. Anything related to Delphi gets so freaking weird, right? Dude. Okay, so I'll tell you what the weirdest interaction was for me today was after all of it was like said and done. So I did not drive myself to um, the court hearings today. My husband drove me and dropped me off because I broke my little toe and I fractured my other 4 toes. The only toe that didn't get broke was the big toe. How did I do this, you ask? Well, my husband has this very large like grinder or whatever that he likes to use when he sharpens the kitchen knives, and he decided that he was going to move it to the end of the couch in my little hallway, like right here at the end of this couch, while he was cleaning the kitchen floor. And he didn't put it back. Well, I fell asleep on the couch. You know, it's like the middle of the night and you get up and you're half asleep and you're walking, right? Pitch black. And what happens? I clocked my foot straight into that thing and bam. So he got to drive me there today. So I didn't get to like leave right away, but my phone, I have AT&T service, I have 5G, and I have one of those Galaxy 5V flips, a great phone. I've never really had problems with it getting service before, but for some reason over there at that building, like service was dead. I couldn't get a phone call out. I couldn't even like get on the internet to like, it wouldn't even let me upload my video to let y'all know that I had made it and that we would be talking about this evening. So, um, after I came out of the courthouse, I was trying to get signal so that I could call my husband. And at one point, I was able to walk over to a spot and I got signal and I was able to call him to let him know, hey, I need you to come get me, right? Well, the bailiff that was in the courtroom walked over to me and he asked me how I was doing. And I was like, I'm doing good. How about yourself? And he's like, I'm doing really good. He's like, I'm wearing my press pass. And he comes over and he looks at my press pass and he's like, so you have a media press pass? And I said, yes. And he's like, what station are you with? And I said, I'm not with a station. I am independent. And he said, do you get on the YouTubes? The YouTubes. Not even just like YouTube, the YouTubes. And I said, yes, I do get on YouTube and I do talk about, you know, the experiences that I have come across attending these hearings. And he said, he said, how much money you think somebody make when they got 3.3 million subscribers? I don't know. I have no idea. I'm not monetized. I don't want money for my channel. Like I'm not interested in monetization even when it comes up. He's like, yeah, but how much would you make? I was like, I don't know. I said, there are plenty of websites online that you can get on and you can kind of look, you know, and figure out like what people are pulling in. So he like steps closer to me for a minute and he's like, so you have a family member or something that was in here today? And I said, no. And he was like, well, what were you doing here? And I told him that I was there to attend the hearing for Mitch Westerman. He's like, I don't think I know who that is. And are you like, was he supposed to be in court today? Well, first of all, you were the bailiff in the courtroom. I think you pretty well knew that he was on the docket list, but okay, right? And I said, well, that was the gentleman that was being accused of obtaining documents and crime scene photos in the Delphi murders. And he said, the Delphi murders? What's the Delphi murders? I said, the two girls, Abby and Libby, that lost their lives on, in the woods crossing crossing the bridge. He said, oh, yeah, them. And before he could get another word out, my husband pulled up and I was like, thank God. And I was like, dude, I got to go. My husband's here. Peace out. And I just jumped in the truck, but it was just so, I don't know. It was really strange to me. I don't know. People can't comprehend a free press. Apparently not. I don't know. But it struck me as strange that he claimed to not know like the situation about the Delphi murders or Mitchell Westerman, especially when he was the bailiff in that courtroom. You aren't really that great at playing dumb, man. Because like, you know how when somebody acts like they don't know something, but they're looking dead at you and you know that they know what you're talking about, like that look that comes across their face before they get, decide to try to change it to a look of bewilderment. That's pretty much what that was. So yeah. So, I mean, I'm at a loss for words because now we know nothing about who all was involved in this whole scheme of things. He probably doesn't follow true crime. He might not, but I mean, it is what it is. I thought it was weird, I would think that if you were working in a position like that, you would try to keep yourself maybe aware of something, like if it could tend out to be like a higher profile or attention case, you know what I mean? Because it's a security measure. What if you had somebody show up and they were, dangerous? You would want your staff, I guess, to kind of be aware. I don't know. Do you know, will there be another hearing or is it done with Westerman then? Well, what I would think is that after signing the agreement for the pretrial diversion, even though he signed it and the prosecutor signed it, he still has to go in front of the judge for that to be admitted and things like that. So because, you have to go to change your plea from a not guilty to a guilty plea or however that works. So there should be one more hearing for him where he goes before the judge. The judge is going to review that agreement, and then he would then enter into that agreement formally with the state of Indiana. And I do know, I don't know how that's going to work. I would think that if he's going to have another hearing, it will be in the docket. But I don't know. I've also know that a lot of judges, when you go and you plead guilty, a lot of the times the judge is going to say, okay, you're pleading guilty. Tell me what you did that you're pleading guilty to, so that I know that you understand what it is that you came before me for and what you're taking responsibility for. So I've seen some judges where they will require a defendant to provide an explanation. So maybe that might be something. I don't know. It still remains to be seen at this point, I guess. So, yeah. Does anybody have any questions or anything? Yeah. So today it was pretty interesting today. But I really think that it was unprofessional to leave everybody just kind of sitting there and not say anything. Like, I would have thought that the prosecutor and the defense attorney would have wanted to make the judge aware that there had been some sort of an agreement reached, because you know how they go through the document, and even if like a defendant's not there, they still talk about like the things that are going on with the case or whatever, or give an update for the record. There wasn't anything entered into the record as far as that went formally that I saw today. So yeah. So um at any rate, I thank you guys for coming. I appreciate you coming to listen. If you guys have any questions, please feel free to let me know. Um, I don't know what you guys think about these next set of hearings that are scheduled for this next week coming up, this motion in lemony. Do you guys think that we are going to actually make it to these hearings happening? Like, do you think that this is going to go down? Or is it going to be delayed again and something from the Supreme Court come out? I don't know. I'm waiting just as anxiously as everyone else. So when we find out, rest assured that I will keep doing my due diligence and attending everything that I can attend and bringing it back and letting you guys know what's going on. So, with that, I would like for you guys to have a beautiful and blessed evening. Thanks for listening. Have a great night.